Introduction all over again.
No, we'll go ahead and start from there. I believe I just hit the screen share and it should be recording right now. It does say it is recording. Apologize
Perfect.
for that delay. Thank you very much.
Of course.
Am I on the correct slide now?
Next one, please.
Yeah.
All right, so as mentioned, I work at HUD and specifically in our Office of Fair Housing and Equal Opportunity. So as you can see, this is what our mission is: countering and eliminating housing discrimination. We do this through a variety of ways, but primarily we do this through the enforcement of and compliance with a range of civil rights laws and statutes and executive orders that we've been given the authority to enforce. And so essentially we do that in two ways. We assess and investigate individual housing discrimination complaints in my intake and enforcement branches. And then in my branch, the program compliance branch, we work with the recipients of federal funding. So public housing authorities, multifamily housing providers, local governments, cities, counties, and states to achieve and remain in compliance with those laws. Next slide, please. So just to give you a sense of the scope of my office's jurisdiction. So as the first bullet point indicates, our authority essentially extends to every type of housing transaction and housing interaction. And unfortunately, I failed to update these numbers, but these numbers are rather outdated and give an insufficient sense of scope. So according to 2020 data, there were approximately 123 million occupied housing units in the United States, 79 million owner occupied, 43.5 million renter occupied. So that just sets the scope of like the housing market. And then you think within that market, there's a range of transactions, how many rental, sales, lending, insurance, whatever other transactions. So in just the fourth quarter of 2021, there were 3.25 million mortgages secured and 1.8 refinance loans. So we're talking about the scope of what HUD covers is tremendous. It takes up a tremendous size of the part of the economy, a tremendous amount of space. Next slide, please.
All right.
And then Ari, one back.
Hello. So my name is Ari Smith. Thank you, as Nathaniel said, all of you for taking some time to share with us your Monday afternoon and to be here to celebrate Fair Housing Month with us. My name is Ari. I am a staff attorney at Legal Services of Northern California. Our office is in Vallejo and we serve folks throughout Solano County. We also have other offices within our same program throughout Northern California. So you may find us as far up as Chico and Redding, into Sacramento, and then into the Redwood region. I want to just share a little bit of our organization as we get started here. Legal Services of Northern California's mission is to provide quality legal services to empower the poor to defeat and identify the causes and effects of poverty within our communities, efficiently utilizing all available resources. What that means for us is we work on a range of issues, not only housing, including we work on healthcare cases, health insurance access, public benefits, clean slate cases. So that's folks who are exiting the criminal legal system and may need to expunge old convictions. And we work on a variety of different levels. Sometimes that means we are advising folks and going into court. Sometimes that means we are working with local community organizers and government systems. And sometimes we're here in the community talking to folks like you. So thank you for the opportunity to be here. We are going to hand it over to Nathaniel to get started, but just kind of big picture, as Mary said, we have built in some question and answer time. I did want to flag that we probably will not be able to provide individual legal advice on particular specific situations over the course of today's call. We're doing kind of a broad, high-level view of fair housing law. And a bit of a dive into California landlord-tenant law in general. But my organization is around if we do need to provide individual information or advice to folks in individual settings. Feel free to look us up and give us a call. All right, and I'll hand it back to the next slide for Nathaniel.
thanks, Ari. So it seems to make sense before we get into the nuts and bolts of the fair housing laws and whatnot, that we start with defining what fair housing is. So fair housing is essentially the freedom to choose where we each want to live free from discrimination. Which begs the question, next slide, please. What is discrimination? I recognize this is probably a very basic question, but again, we want to make sure we're sort of operating with shared understanding of some of these concepts. So bottom line, discrimination is treating someone differently and often unfairly because of who they are, because of certain immutable characteristics that they possess. So just similar to how I try to very superficially define the scope of HUD's jurisdiction, I always find it helpful to try and define the scope of discrimination, at least housing discrimination in America, as best as we can ascertain. And I realize that this is a lot of like back of the envelope calculation stuff, but I still find it just helpful because a lot of people, when I go out on these speaking engagements, think that housing discrimination is a relic of the past. You know, some of the civil rights era and the passage of the Fair Housing Act was the end of housing discrimination in America. And while we'd all like to think that's the case, and unfortunately it's not. So just trying to provide that sense of what things look like. So some studies estimate that only between 1% and 2% of all housing discrimination incidents get reported each year. So what's that mean in hard numbers? So last year, in calendar year 2021, just about 8,500 fair housing complaints were filed with HUD or our partner local and state agencies. So if we use that 1 to 2% estimate and think that that 8,500 is the 1 to 2% that's reported, that would mean that there was approximately 850,000 incidents of housing discrimination last year. But maybe that's not, I'm not using the right number, that the 8,500 filed complaints isn't actually the right number. So the other way that it gets looked at is how many unique incidents did HUD and the partner agencies, how many unique contacts did HUD and partner agencies receive in a calendar year? So last year, we received just over 33,000 unique points of contact alleging some type of unfair treatment in housing. Whether or not it was discriminatory or not, it was still contact alleging that unfair treatment. So if we use that as our number, we're then talking about approximately 3.4 million incidents of housing discrimination that occurred in calendar year 2021. And this is in line with some recent reports by some national fair housing organizations who estimate that there are annually 4 million incidents of housing discrimination across the country. Next slide, please. So we have that very broad and 20,000 foot level definition of discrimination, but I do want to take a moment just to walk through the three main theories of discrimination that HUD utilizes when evaluating and investigating complaints of housing discrimination and when conducting compliance reviews. Next slide, please. So the first, back one, please.
Yep.
So the first is overt discrimination, which, as this sign from 1940s Detroit demonstrates, is the most obvious and most in-your-face version of housing discrimination. It's that clear and explicit statement of, I will not allow this protected class to access housing, live in our community, whatever it may be. So sort of just that very blatant, in-your-face statement. Next slide, please. So the second theory of discrimination is the disparate treatment or discriminatory intent. So this sign is from a restaurant, and I realize it's not exactly relevant, but it's meant to provide a visual representation of this concept of, here is a restaurant who's implemented a series of rules which only apply to one group of people, in this instance, families with children. So disparate treatment or discriminatory intent would be treating some people less favorably than others because of their membership in a protected class. And we'll get into what the protected classes are shortly. So in terms of housing, this could be something like only asking for citizenship documents from Hispanic or Latino applicants, or refusing to rent ground floor units to single women households, or refusing to rent upper floor units to families with children. Next slide, please. Excuse me. And then finally, we have the disparate impact or discriminatory effects theory of discrimination. So generally speaking, what this refers to is a policy or practice that, while neutral on its face and applied equally to everyone, has a disproportionate impact on one or more protected class groups. So this sign is just meant to illustrate the one example I want to raise to explain how disparate impact looks like. So there's this concept known as a nuisance ordinance. And what a nuisance ordinance does is the jurisdiction implements a nuisance ordinance that identifies various types of behaviors as being nuisance behaviors, and then says a property must take steps to abate that nuisance. So these could be things like grass that's grown too long, the accumulation of trash, but it can also be more problematic things that are defined as nuisances. And the penalties that can be applied to property owners or property management companies can range from fines to liens to the inability to rent that property any longer within the city. So how this can become a disparate impact issue is some nuisance ordinances define an excessive number of calls for emergency service as a nuisance. So it could be a formula such as 3 or more calls within a 12-month window is a nuisance. And as it's a nuisance, then the property owner has to take steps to abate that nuisance, which could include evicting that household to prevent further nuisances from occurring. So this is problematic because in many jurisdictions, domestic violence related calls are the largest category of calls received by police. And when you look at the demographic breakdown of domestic violence calls for police, you see that approximately 80% of intimate partner violence related calls were made by women. So if you have this ordinance that says 3 or more calls in a 12-month window is a nuisance, and you must take steps to abate that nuisance, and you're including women who are victims of domestic violence under that, you can see how that sort of policy can then have a disparate impact against a protected class group. Next slide, please. All right, so I'll focus most of my time on the Fair Housing Act and the things that the Fair Housing Act allows for, such as reasonable accommodations and whatnot. But this is just one of the laws that my office enforces, though arguably the main law that my office enforces. So the Fair Housing Act was first passed in 1968 following the assassination of Dr. King, and it's later been amended as recently as 1988. And the Fair Housing Act prohibits discrimination in the sale, rental, financing of housing. Next slide, please. So the Fair Housing Act essentially applies to everyone. There are some exceptions to this, housing for older persons, other stuff, but essentially the Fair Housing Act applies to all private landlords, colleges or universities that provide housing, and it applies to all recipients of federal funding, those housing authorities, other subsidized housing developments, cities, states. So the Fair Housing Act captures the broadest, or has the broadest reach. And the Fair Housing Act establishes these 7 protected classes: race, color, national origin, religion, sex, disability, and familial status. Later on, we'll define disability in much clearer terms, and I'll touch on some of these terms in a moment, but I wanted to make a few quick notes about some of these protected classes before we define other ones in greater depth. So it's important to note that religion also includes the absence of any religion or a specific type of religious belief. So atheism or agnosticism would be included in the religion protection. Race, color, national origin, and sex apply to all races, all colors, all national origins, and all sexes. And the Act prohibits discrimination based on someone's association with a member of a protected class. So I don't have to be the member of the protected class in question if I'm being treated differently, if I'm being discriminated against because I associate with someone of a protected class, then I'm also protected under the Fair Housing Act. And I'm protected under the Fair Housing Act if I'm discriminated against because someone perceives me to be of a specific protected class. So one thing I failed to include a slide on, but it's important to point out, is that following a Supreme Court decision in 2020 that held that Title VII, so a different law altogether, but that Title VII's prohibition on discrimination in employment because of sex also covers discrimination on the basis of gender identity and sexual orientation. This was then applied to Title VIII, which is the Fair Housing Act. So in 2021, my office, Fair Housing Equal Opportunity, implemented an executive order that directed us to interpret all statutes, including the Federal Fair Housing Act, that prohibits sex discrimination to also prohibit discrimination based on sexual orientation and gender identity. So it's important to keep that in mind. Sex is now covers more than just sex. It covers the sexual orientation and gender identity. Next slide, please. So the Fair Housing Act, this is a non-exhaustive list of prohibited activities under the Fair Housing Act. It's important to remember that these activities must be connected to a protected class. It's the refusal to rent because of membership in a federally protected class. So, I'm not going to walk us through all these lists, but things like refusal to rent would include an action like representing to me that an apartment is not available when in fact it is available, or somehow otherwise making a unit unavailable or denying me a dwelling. Differential treatment or different terms and conditions would mean it's illegal for a housing provider to set different terms based on my protected class, whether it's about renting the unit, buying the unit, or in regards to whatever services or facilities that property might offer. So things like placing restrictions specific to families with minor children, or setting families with children in a specific part of the property, refusing to renew the lease of someone with a disability because of unfounded concerns of liability, or allowing a community room to only be used for one religious group's Bible study, but not another religious group's Bible study. So as you see, the Fair Housing Act also prohibits the making of discriminatory statements. So you can't make, print, or publish any sort of statement that indicates a preference, a limitation, or any discrimination based on protected class. The Fair Housing Act also has anti-retaliation provisions in it. So someone cannot be retaliated against for the act of exercising their rights that are afforded them under the Fair Housing Act. Next slide, please. So just to provide a little more information on the protected classes we walked through that we didn't yet define. So familial status includes the presence of one or more children under the age of 18, a pregnant woman, someone that's otherwise in the process of acquiring legal custody of a child. So this can be parents, step-parents, adoptive parents, guardians, foster parents, or custodians. Next slide, please.
Come on.
Nope.
Too many, huh? There we go.
And this is a very long quote about national origin, but it's important to recognize how broad national origin can be. So it's not just ethnicity, but it can be someone's ancestry, someone's culture, or someone's language. So we're talking about sort of that whole thing that can inform someone's birthplace and backgrounds. And I believe next slide goes back to Ari.
That is correct. I am picking
Sure.
up where Nathaniel left off with talking about the California laws that are similar to the federal laws, which Nathaniel just walked us through. So the central law in California, which is going to mirror a lot of the protections in the Federal Fair Housing Act, is called California's Fair Employment and Housing Act. So this one puts protections for employees and people in housing in kind of a similar set of protections. Most of what we're just describing would also apply in an employment context, but we are of course going to talk about the housing context. This is in California Government Code, section 12900, if you want to look at the fun code sections yourself. And it mirrors most of the kinds of protections that can be found in federal fair housing as well. For example, prohibitions on discrimination in renting, placing conditions on certain kinds of housing for individuals in protected classes, retaliation, those same types of protections. And it covers all of the same protected classes, race, religion, national origin, family status that Nathaniel described, plus some additional classes in California. The additional classes in California, well, as Nathaniel described, there has been a federal interpretation of the Federal Fair Housing Act's prohibition of discrimination on the basis of sex to include gender, sexual orientation, gender identity, and expression. Each of those are spelled out specifically in California law. So the result is the same, that people are protected from housing discrimination on the basis of being transgender, or on the basis of their sex, or on the basis of sexual orientation. But it's spelled out specifically in the California law in each category. And California's Fair Employment and Housing Act also prohibits discrimination on the basis of ancestry, marital status, age, with the exception that senior housing is permitted under certain circumstances, source of income, which we'll talk about a bit more, whether someone is a veteran or is in the military, genetic information of a person, and someone who is perceived to have or is associated with the above characteristics. So that last one means perhaps someone does not identify as having a disability, but might be perceived as being disabled by their landlord, that the protections that apply to folks with disabilities would still apply to that person on the basis of that perception. Next slide. I wanted to take a moment just to talk a little bit more about what it means to protect folks on the basis of source of income, because this is a fairly recent change to California law. Source of income, it most commonly means someone who has a voucher of one kind or another. It would also include receiving government benefits, so cash aid, CalWorks, food stamps, things like that. But the most common context in housing are vouchers such as the Section 8 program or housing choice vouchers through the local housing authorities throughout Solano County. There is also a HUD VASH program, which places veterans with vouchers. And so that means that housing providers cannot refuse to accept a tenant on the basis of having a voucher as their source of rental payment rather than paying it out of, say, income from a job. That means landlords cannot say advertise no Section 8 or we don't accept Section 8. That would be a violation of fair housing law because it's not providing an equal opportunity to folks in a protected class. Housing providers can have folks who have vouchers follow the same application processes as any other applicant. So that can include credit checks, proving income, proving identity, things like that, with the exception that when someone has a voucher paying a subsidy on their rent, To make sure that someone is able to pay their rent, landlords often check that someone has 3 times the income of their rent. So for someone with a voucher, that would only be 3 times the income of the portion that the individual is responsible for, since the rest of that rent would be paid by the government agency, whether that's a housing authority or HUD providing the voucher. Next slide. And we've reached our first question break. We've been keeping an eye on the chat. And I see there's just now a question, how to avoid some tenants from abusing landlord and or property. We can talk that through. And there was a question about the number of units or percentage that an apartment building can rent to Section 8. I think I see that that one was answered. There's no limitation. In fact, as we just said, all units are available to folks with Section 8, although that's not a requirement that folks receiving Section 8 have to receive a certain number of units, as long as the process for application is not discriminatory. And I see someone named Lee asked about landlords from abusing landlord and or property. Maybe if you can clarify the question, or if you want to pop on, we can talk a little bit about, I remember Nathaniel discussed a nuisance ordinance and kind of what the boundaries are of that. A typical lease can, of course, include provisions that apply to all tenants equally, like prohibitions on damaging shared physical property, things like that. And that doesn't violate fair housing law because it is equally applicable and pretty closely related to the point of providing housing. The difference between that and, say, a nuisance provision that could be problematic is, oh, Lee, did you want to weigh in?
Yes, I have experienced tenants that abuse the landlord. They will report 3 occupants and they end up with 6 or 7 occupants. That destroy wear and tear, and they also, because it's not their property, they punch holes on doors and I also have experienced tenant that thinks that landlord has money for new appliances. So they will report certain things not working, even though it's working, or they would do something to it and certain things, and they expect landlord to pay for whatever they have done to it. To me, it's an abuse.
Okay, we are going to talk a little bit about general landlord tenant protections, which would include repairs towards the end of this presentation. But the general, so I heard you mention a concern about the number of inhabitants in a unit. That, of course, can implicate family status in terms that folks who, for example, a landlord or housing provider cannot refuse to rent to a family on the basis of having children or having an elder who lives with them. However, of course, a housing provider, a lease agreement can include things like, here's the process for getting repairs done, here's the, typically the rule is that a landlord is not responsible for any damage caused by tenants. Tenants are responsible for that, whereas a housing provider pays for repairs that are due to normal wear and tear, things getting old. Nathaniel, do you have anything you want to add?
Yes, I also have experienced a tenant illegally planting marijuana close to school units and so on without landlord's knowledge or approval, because illegal activity is usually not allowed. It shouldn't be allowed by any landlord.
We will talk a little bit about what are the lawful reasons that a landlord can end someone's tenancy, which does include illegal activity. That said, marijuana is no longer illegal in the state of California. So depending on the nature of someone's possession or use or growth of marijuana, it might or might not be illegal.
Well, anyone that plant anything marijuana without permit is still illegal.
Like we said, we were not able to answer super individual questions. So I, without knowing the details of the situation, I can't get into the details, but I will come around to the grounds for terminating a tenancy at the end of this presentation. And I wanted to briefly answer some questions I saw in the chat. Are you saying that a landlord cannot say that they don't take Section 8? That is correct. It is unlawful discrimination to post a housing ad that says no Section 8, or for a landlord to have a policy of refusing to rent to people with Section 8 or housing choice or HUD-VASH vouchers. I see someone else related said, my company takes Section 8 if the voucher covers all of the rent. Is that legal? And just to make sure I'm understanding that, that certainly is legal. I think there might be an issue if that is the only circumstance where a housing provider accepts Section 8, because receiving a voucher is a protected class. A landlord should not be refusing to consider or rent to people with Section 8 if they are able to meet the other criteria in the application process. And another question was about considering CalWORKs as income. Yes, since CalWORKs and other government benefits are considered a source of income protected under, protected under California's FIHA, then they do count towards income in terms of verifying a tenant's ability to pay the rent. And then I see someone added, is there things a property has to do to qualify for Section 8? If you do enter, if a housing provider does enter into a lease agreement with someone who has a Section 8 voucher, then that starts a process with the local housing authority, which I think Mary actually might be well positioned to weigh in on if you'd like to
I
talk
can
about that at all.
I can go ahead on that one. There's no property that is ready for Section 8. What we do is we work with the landlord to make sure that the minimum housing quality standards are met. We do an inspection. We'd be glad to talk with the landlord if they've got additional property that they'd like to make available to Section 8. We can always refer. Our technicians have tenants that may qualify based on the rent amount. We know what you're asking and then what the subsidy is. We can do that for you. We'd be glad to provide additional information, but there's not a property that is Section 8, but we're gladly looking at taking on new properties that you may have and would like to put a Section 8 tenant in there that has a voucher.
Right. All right. Great job with all those questions. They're coming all right at you.
Anything you want to add?
No, that's good. I unfortunately, since my area of expertise falls so far outside the scope of like a lot of the landlord tenant concerns, I'm not an expert in answering. So you did a masterful job on that. Well, we might as well dive into the next stuff. So we'll tackle reasonable accommodations and reasonable modifications. So I'll start off with the accommodations and then Ari will tackle the modifications. So we can go next slide and then probably just skip that. Next slide, and then we'll go next slide right there. We go, perfect. So before we get into reasonable accommodations, of course, we need to define disability. So as we see here, disability is a physical or mental impairment which substantially limits one or more major life activity, a record of having such an impairment, or being regarded or perceived as having an impairment. Now, it's important to note that California has a different definition of disability. So this is the federal definition for the Fair Housing Act, but I'll make sure you're up on how California defines it. And I also want to note that this definition does not include the current illegal use of drugs, but does include someone who is in recovery from substance abuse. Next slide, please. Oh, actually, we can go back. All right, let's go back one more. Sorry. I should probably give a little more. Oh, back the other way.
Which way are we going?
Left. I mean, reverse. Wind it back.
Is that not going reverse?
There we go. We'll go back one more. There, we can stop there, I guess. So I just want to provide a little more context just to give a sense of disability discrimination in housing. So for my entire time with HUD, and most likely my entire time in fair housing, disability has been the most cited protected class basis of complaints that have been filed. So just earlier today, I ran a report to see what that looked like. So for the 5 calendar years from 2016 through 2021, approximately 60% of all complaints that were filed cited disability. And of those complaints, almost 70% of the disability complaints alleged denial of reasonable accommodation, approximately 20% of which were just about service, support, or assistance animals. So you see that the vast majority of the complaints that HUD and the partner agencies are receiving are disability, and most of those are about reasonable accommodation requests. So it's important that we keep that in mind because of the prevalence of this protected class and the prevalence of reasonable accommodation requests. That's why this ends up being an area of focus for us. So we defined disability and noted that it was something that substantially limited one or more major life activity. So what are major life activities? They're broadly broken down into these three categories of physical, mental, and developmental. And those are pretty self-explanatory. Physical, things like walking, seeing, hearing, speaking, performing manual tasks. Mental would be things like learning, working, cognitive-based things. And developmental would be about the ability to learn with an onset, generally speaking, before the age of 18. Next slide, please. So a reasonable accommodation is a request for a change to a rule, a policy, or a procedure that would allow an individual with a disability to have an equal opportunity to use and enjoy a dwelling, which does include the public and common use spaces. Next slide, please. So some very general examples of reasonable accommodation requests. Obviously, the service support assistance animal request in a no animal building, request to relocate to a ground floor or otherwise accessible unit, request for the extension of a voucher. Next slide, please. So a request can be made by the individual with the disability or someone on that person's behalf. And that request can be made at any time before and during tenancy. The request can be made orally or in writing. It doesn't have to be on any specific type of form. You can't require someone to submit a reasonable accommodation request in a specific format. And we'll walk through some of these other points momentarily about under what situations a housing provider can deny a reasonable accommodation request, what sorts of verification can be requested from an individual making a reasonable accommodation request. Next slide, please. So whenever someone receives a reasonable accommodation request, you have to keep in mind that the response to that may not be unreasonably delayed. Now, there's no set definition about what constitutes a unreasonable delay, but the point of this is to recognize that at some point, a delay can effectively act as a denial, especially if someone's reasonable accommodation request is very timely. They need this change to the policy, practice, or procedure in order to use that dwelling, and to delay the processing and response to that request can function as that denial. So it's important to respond to these requests in a timely fashion. You cannot unreasonably deny a request, and we'll define that in a moment. And the granting of a request cannot be conditioned on the payment of an additional fee or a deposit or setting other terms and conditions upon the granting of that reasonable accommodation request. Next slide, please. All right. So when a reasonable accommodation request is submitted, the first thing that we look at is whether or not there is a nexus or identifiable relationship between the disability and the accommodation being requested. Next slide. So depending on what we might know about the person making the request and what the request is, that nexus might already be established for us. So in the situation where someone's disability is obvious or otherwise known to you as a housing provider, and if the need for that accommodation is readily apparent or known, then you can't ask for any more information about their disability. So the obvious example would be an individual with a mobility-related disability who asks for a reasonable accommodation for an assigned parking space immediately in front of their door. You see that they rely on a walker or other mobility assistance device, and that they have problems traveling long distances. So their disability is obvious to us, and their need for this accommodation is known to us. So in that situation, we can't ask for additional information related to the disability. Next slide, please. Excuse me. So sometimes the disability can be readily apparent or otherwise known to us, but the need for accommodation might not be. An individual in a wheelchair who submits a request for an emotional support animal has a visible or obvious disability, but doesn't necessarily have a obvious or known need for that reasonable accommodation request. So in that situation, a housing provider can request additional information that establishes the disability-related need for the accommodation request. Next slide, please. And then, oh, back one, please.
Okay.
And then the final scenario would be where neither the disability or the disability-related need for the accommodation is known or obvious. So then a housing provider can request information that establishes that the person meets the definition of disability, describes the accommodation that's being requested, and clearly establishes the nexus or that relationship between the disability and the requested accommodation. Next slide, please. So when you do have to ask for information about a disability, it's important to remember that you're not asking for specific diagnosis. Someone can identify or provide medical documentation that demonstrates that they have a mobility disability. They don't need to tell you exactly what the specific diagnosis is. The verification does not need to come specifically from a doctor. It can come from any healthcare professional or anyone who has knowledge of that person's disability. So as this bullet point demonstrates, that can be social workers, psychiatrists, other mental health professionals, including counselors. There are even some situations where an individual with a disability can self-certify as disabled. So it's just important to recognize that this verification can come from a range of sources. And as we all know, when receiving disability-related documentation, it's important that that documentation is secured and only available to those who need to know. Next slide, please. All right, so there are some situations when a reasonable accommodation request can be denied. When it was not made by or on behalf of an individual with disability, when there's no disability-related need for that accommodation, or when that request is not reasonable. And next slide will define what reasonable means. So that is when the accommodation, when granting the accommodation would pose an undue financial and administrative burden, or when granting that accommodation would fundamentally alter the nature of the housing provider's operations. Next slide. So undue financial and administrative burden is something that's done on a case-by-case basis. And you look at a range of factors, including things like the cost of a requested accommodation, the financial resources of the provider, things like that. The example that I always give of undue financial and administrative burden is the situation where a tenant's sole source of income is SSDI, and they receive that payment on the 5th of the month, but the landlord collects rent on the 1st of the month. So in the situation where that landlord, that housing provider, is a small housing provider who relies on the timed payment of rent in order to make their mortgage payments, my request to allow me to pay my rent on the 5th could endanger your ability to pay your mortgage. And in that situation, my request could be an undue financial and administrative burden on the housing provider. Next slide, please. So the other definition, the other bullet point under the definition of unreasonable was this concept of the fundamental alteration of services. So the situation where my reasonable accommodation request is asking you to provide a service that you don't currently provide. So if I ask you to walk my emotional support animal, or if I ask you to come to my unit and collect my garbage, unless you are already providing garbage collection services or operating a dog walking business, I'm asking you to fundamentally alter how you operate as a housing provider. And in that situation, then my request would be unreasonable. Next slide, please. All right, so we'll touch on direct threat later as well when we get into the assistance animals side of things. But there are some situations when someone's mental health disability can result in an action which can be seen as posing a direct threat. So when you're making this assessment, when you're identifying someone is a direct threat, that must rely on this individualized assessment based on reliable objective evidence, not stereotypes that people with X disability endanger the rest of us, but this actual individualized assessment of the objective evidence. So things like what happened, when did it happen, what resulted from the occurrence, will this occurrence happen again? Has that individual taken any steps to address the underlying situation that may have caused the original disturbance? Have there been an adjustment in medications? Has there been a change in whatever support or other services they're receiving? Is there a reasonable accommodation request that would eliminate the risk of any future direct threat? So sort of taking those steps, looking at those various things when we're evaluating whether or not an individual poses a direct threat. Next slide, please. All right, so when a reasonable accommodation request has been identified as presenting either that undue financial and administrative burden or the fundamental alteration of services, you've denied that request. However, you must then enter into what's known as this interactive process where you're engaging with the person that made the request to identify potential alternative accommodations that would meet the needs of the person who made that request. Now, it's important to keep in mind, though, that the person with the disability who made this request most likely is going to have the most accurate knowledge about the functional limitations posed by the disability and of what types of alternate accommodations would provide them that equal use and enjoyment of the space. So they're not obligated to accept the alternative accommodations posed by the housing provider when it doesn't meet their needs. So while you're engaging in this interactive process, you are in effect, though, recognizing that that person is the expert of their own disability and of their own disability-related needs. Next slide, please. All right, so who pays? So generally speaking, under the Fair Housing Act, the housing provider is responsible for the costs associated with a reasonable accommodation, unless, of course, that accommodation poses that undue financial and administrative burden. And I believe that's it for my section. Next slide, please.
Thank you. And thanks to the folks who've been chiming in the chat with questions. I have gotten to a couple of folks. I realize there were a few I haven't gotten to yet. Some of the questions, particularly about assistance animals, we are going to cover in a whole section about assistance animals shortly. And I'll try to come back to anyone we missed as well. So I am going to talk now about reasonable modifications, which are as distinct from reasonable accommodations. A modification is a physical change to a building or a structure. Next slide, please. So the general definition that we're going to take from the joint statement of the Department of Housing and Urban Development and the Department of Justice. A reasonable modification is a structural change made to existing premises, occupied or to be occupied by a person with a disability, in order to afford such person full enjoyment of the premises. That can include structural changes to the interiors and exteriors of dwellings and to common and public use areas. So a modification is something tangible that you can touch in physical space. An accommodation is a change to a policy or a procedure. Next slide. And these are some examples of things that could be reasonable modifications depending on the facts and the circumstances for an individual's specific disability. That could be installing grab bars in a shower so that someone who has limited mobility or trouble balancing can use the shower safely. Installing a ramp for wheelchair access. Installing a front-loading washer or dryer instead of a top-loading one, depending on someone's mobility. Installing an automatic shut-off faucet for people with cognitive disabilities so that the water isn't running if they forget to turn it off. Providing a visual alarm for people who are hearing impaired, or on the other hand, providing an auditory alarm for people who are visually impaired so that people are able to have the same information if there's an emergency, if there's an alarm, in a way that they can sense and respond to. Next slide, please. So much of the rules for reasonable modifications is going to mirror the rules for reasonable accommodations with a couple of differences that we will talk through. Like a reasonable accommodation, a person can request a reasonable modification at any time from the beginning of the application process to upon moving out. The Fair Housing Act doesn't require any particular format. Someone can request a reasonable modification verbally or in writing. They can have someone who they authorize to make that request for them, a family member or someone who acts on their behalf. A person with a disability cannot go ahead and just make a modification and then go and apply for the reasonable modification. They need to get the approval before making the modification. Like a reasonable accommodation, a housing provider cannot have an unreasonable delay in responding, just waiting for a long time to get back to someone on their request for reasonable modification. If a housing provider takes an unreasonably long time, that's considered a denial because the person isn't able to access their unit in the way they need while that request is out there pending. And next slide. Just like a reasonable accommodation, a modification has to be something that is related to the individual's disability. So there must be a nexus, a relationship between the person's disability and what they're requesting. Next. And so the upshot of that is that the same kinds of information are relevant if someone requests a modification. So that includes things like, what's the nature of someone's mobility limitation? Do they have trouble standing, walking, moving around? Not necessarily things like what someone's specific diagnosis or condition is. And then there are some specific rules that are unique to reasonable modification, since we're talking about making physical changes to a building. A housing provider cannot require a tenant to move to a different unit instead of allowing them to make a modification. For example, they can't say, oh, there's only one accessible unit, you have to live in the accessible unit, instead of letting someone make a modification where a unit would become accessible with one modification. In general, the housing provider cannot insist on the specific way that the modification or the design will be if they want a different modification or design than the one that the person requesting the modification has requested. On the flip side of that, if the housing provider wants a more costly design or version, then the provider covers those costs. We'll talk a little bit about who pays in a minute. Much of the payment for reasonable modifications would have to be borne by the tenant, the person requesting it. The housing provider can, of course, request for a description of the modification before authorizing someone to go ahead and make a change to the premises. And they can require that the requester get any building permits if it's going to be something substantial like putting in a ramp, and that the work has to be performed in a workmanlike manner is the standard, meaning legal, up to code, not just kind of a DIY operation. And next slide. In terms of making the modification itself, the housing provider can, like we just discussed, require that the person who wants the accommodation to get any building permits that are necessary and that the work be performed in a workmanlike manner, but not to, the housing provider cannot require additional insurance or an additional security deposit or the use of a particular contractor. So they can set standards for, like, you need a licensed contractor to do this, but not, you can only have this one specific contractor do it. Next slide. And then the most significant difference between a reasonable modification and a reasonable accommodation is that in a reasonable modification, the tenant is generally the one who has to pay for those costs. So in the example of installing shower grab bars or something like that, that would normally be borne by the tenant. The exception is if a landlord wants a more costly version or design of a modification, then the tenant pays what it would cost to have the basic form installed, and the housing provider pays the difference between the basic version and the more costly version. Next slide. And then there's also the question of who pays for the upkeep of modifications to a building. The tenant is responsible for paying for the upkeep and maintenance of a modification that they exclusively use. So generally that's things inside a tenant's own unit. It could be an accommodation alarm that is visual or auditory, or plumbing that has automatic shutoffs or grab bars, things like that. A modification that is made to the exterior or a common space in a building. So that would include things like ramps or automatic doors that open. In those cases, a housing provider is responsible for the upkeep and maintenance since it's used throughout the building. And next slide. Okay, and I think we had a question in the chat about this exact issue. So if someone does make a modification and they've come to the end of their tenancy and are moving on, well, what happens to that modification? The rule is a little, the law loves the word reasonable. So if for these reasonable modifications, the rule is going to be that a tenant must restore the unit to the condition it was in when they moved in, if it is reasonable to do so. And if the housing provider requests it. In some cases, you may not want to, right? Like if you leave grab bars in the shower, then that's an accommodation for the next person, potentially. It doesn't really diminish someone else's ability to use the unit. In some cases, it might not be a good idea to leave the modification in place if it's something that is pretty unique to an individual. And so in those cases where it's reasonable to do so, it doesn't require major expense, major change to the premises, then a housing provider can request that the tenant restore it to the original condition. In general, if the modification doesn't affect the next person in the unit, the tenant can't be required to restore the modification to their prior state. So again, modifications that are pretty minor, like someone can use a front loading dryer as well as a top loading one. That's not really a negative thing for the next person moving in. A tenant would probably not be required to return that to the original state. And that is treated differently when a modification is made to the exterior of a dwelling or to common spaces. So things like wheelchair ramps, which are pretty significant investments of infrastructure, a tenant is not required to undo those upon moving out. All right, with that to the next one. That brings us to the end of our quick overview of reasonable accommodations and modifications. We are going to do a dive into service animals specifically next, but with that, I will take a minute to read up on any questions in the chat and folks can chime in. Okay, I see that Tom has asked, are you saying that if a tenant requests the alterations, the landlord is to cover the cost? In general, no. Generally, if a tenant requests a physical modification to the unit, the tenant is responsible for the cost, with the exception of a situation where a housing provider is opting for a more costly design.
And the other exception would be if, as a housing provider, you are the recipient of federal financial assistance, which does not include accepting housing choice vouchers or Section 8 vouchers. But if you are the recipient of federal financial assistance, then a reasonable modification is treated the same as a reasonable accommodation, and the costs associated with that would be borne by the housing provider. The only other exception to that is if a property that is subject to the design and construction requirements of the Fair Housing Act fail to be constructed in an accessible manner, and the person's modification request is asking you to do what you should have done under the design and construction requirements, then the costs associated with that type of modification could fall on the shoulders of the housing provider.
Thank you for those details. That is exactly right. And the exception for buildings receiving federal subsidies is not going to apply to most kind of small landlords. It's kind of, larger public housing structures that are subsidized by HUD have a different set of rules. I see there was a question about tenants who made a modification without getting it approved and moved out without restoring it, and the security deposit did not cover the modification. What can the landlord do? Again, so some of the analysis is whether it's a minor modification that won't impact the next person's use. Minor things like lowering the height of a towel rack or installing a grab bar might not need to be restored for the next tenant. I assume this is a more substantial one, in which case, just like any other security deposit issue, normally the process is to itemize the cost necessary and bill the tenant, and then if necessary to go through small claims court to resolve that. Oh, I see that there was a great case study example in the chat here. Someone mentioned having a tenant request putting in fencing to support a child who had autism and prevent them from wandering off, and then that conflicting with other people's use of the common area. I think that this is a really good example of the limits of what constitutes like a fundamental alteration, and whether this is a reasonable accommodation, modification, putting in something physical, or whether it is impacting other individuals too much. So I'm not going to give a crystal clear answer because I don't know all the facts, but Nathaniel, do you have any questions or how you might approach it?
Yeah, that's a hard one. And certainly a unique one. I think my first question would be about how clearly they established the nexus between their child's disability and that requested accommodation. And assuming that they've satisfied that, then you would do that other analysis. And, I don't want to weigh in on the specifics of any one situation, but I think Ari's pointed out, does subdividing the common space for one specific person, does that constitute a fundamental alteration of the services I'm offering as a housing provider? I think that'd be sort of the analysis I would apply to it.
Yeah, that is a great question. And it's a good example of where it gets kind of thorny. There's not a crystal clear answer, and it would depend a lot on the individual circumstances and the nexus there. With that, I think we're going to move on next to a dive into the #1 hottest topic in reasonable accommodation, which is service animals and accommodation animals. I see people are excited, and so am I. So I'll let Nathaniel kick it off.
Yeah, I saw David out there. David's doing the wave, but with the waves behind him. I see that. So thank you, Ari. Can we go to the next slide? There you go, Mary. Look at that. All right. First of all, we've gotten some fantastic questions so far. So I really appreciate how attentive and engaged everyone remains. There are times I fear that because of how inhospitable the online format can be, that you just end up speaking out into the ether and not getting anything back. So it's really refreshing and encouraging to see how many questions people are submitting. So thank you so much for your continued attention and responsiveness with these questions. As I tried to allude to with the last set of stats I provided, the service support assistance animals are one of the largest subsets of the reasonable accommodation requests complaints that we receive at HUD and at the partner agencies. And when I do these fair housing overview type engagements, this often ends up being the section that generates the most questions. And by the responsiveness I can see out there, I won't be surprised if that remains true today. A lot of the process that I just will describe in the next few slides is going to sound really familiar, as we're essentially following the same steps we would with any other reasonable accommodation request. So I apologize if it is a little repetitive, but there are some things that are specific to the service support assistance animal world. So that explains my repetition. Next slide, please, Mary. All right, so at this point, it's not that recent, but there is this somewhat recent HUD guidance specifically on the service support assistance animal topic. Now, prior to this guidance that I'm citing here, there was another guidance that dealt with how you evaluate the requests for these animals under the multitude of laws that can apply. So it's not only the Federal Fair Housing Act, but Section 504 and the ADA. Now, the ADA and Section 504 are only going to apply to those recipients of federal financial assistance. And again, for our purposes, that does not include housing providers that accept housing choice vouchers. So we're primarily going to focus on defining service support assistance animals under the Federal Fair Housing Act. So these animals, which I'll generally refer to as assistance animals, are animals that provide a range of disability-related functions. So it's not only what we traditionally think of when we think of a service animal, the guide dog or the other like physical assistance type animals, but it's animals who provide the emotional support or provide other services that may be less obvious to us. Those dogs that help identify impending seizures or provide other types of assistance like that. Next slide, please. So if a property does not allow pets, or if a property has other pet-based restrictions, pet deposit, pet rents, then an individual can make a reasonable accommodation request to either have the no pet policy waived or to have these other pet restrictions waived, because the animal in question is not a pet. The animal in question is, somewhat grossly speaking, a disability device. It's something that's there to provide a disability-related service for that person. And as such, it is not subject to rules that would otherwise apply to pets. Next slide, please. So I got ahead of myself. So service animals are not pets. So again, no pet deposit, no pet rent. And this second bullet point is the key one. So under the ADA, there is the training requirement. So service animals under the Americans with Disabilities Act have been trained to provide a specific disability-related service. Now, under Section 504, which again only applies to the recipients of federal financial assistance, so most importantly, under the Federal Fair Housing Act, there is no training and no certification requirements. So again, no training, no certification requirements. Also, unlike under the ADA, dogs are not the only type of service animal allowed under the Fair Housing Act. Now, the ADA does also allow in some situations miniature horses, but essentially the ADA is talking about these specifically trained service dogs, whereas under the Fair Housing Act, it's any animal, no training requirement, no certification requirements, and these animals are not subject to breed, size, or weight restrictions. Next slide, please. So this is where it's a little repetitive, but it's just a reminder, when someone submits a request for a reasonable accommodation request to be able to have their assistance animal, then you sort of ask these two questions. Does this person submitting the request have a disability? And is there a disability-related need? Is there a nexus between that person's disability and their request for the assistance animal? Next slide, please. So if the answer to both those questions are yes, yes, that individual has a disability, and yes, that individual has a disability-related need for the assistance animal, then under the Fair Housing Act, you grant that reasonable accommodation request. And in doing so, that assistance animal is allowed to accompany that person all around the premises where that person would otherwise go. Next slide, please. So again, I'm sort of repeating myself here. There must be that nexus, that identifiable relationship between this accommodation request and the person's disability. Next slide, please. So I told you we'd come back to direct threat. This often comes up with animals. So when we're talking about direct threat with animals, this is not something that's based on stereotype or fears of a breed of animal. And every time I get to this slide, I always kick myself for not looking at the data, but I swear the animal, the dog who is responsible for the most bites on an annual basis is always one that's shocking and that people don't expect. For a while, I thought it was a Dalmatian, but I think it's something that just like you would never expect, because the common misconception is that the pit bull or Staffordshire Terrier is the breed most responsible for dog bites. So I bring that up just to highlight that we can't base our determination of direct threat on stereotypes or misconceptions of a threat posed by an animal. Instead, as before, we're doing this individualized assessment of what threat that specific animal poses. Has that specific animal attacked someone, caused the property damage, engaged in these behaviors, demonstrably done things that demonstrate this direct threat, not this fear or opinion about what that animal might do. And let's say that my animal does in fact pose a direct threat. I have not lost my right to a reasonable accommodation for an assistance animal. I may have lost the opportunity to have that specific animal that poses a direct threat, but that does not mean I can't obtain a new service animal that does not pose that direct threat. Next question, please. Next question. Next slide. You want me? Back one, please. All right, so this is just talk about, this is the first guidance I was referring to that will walk you through what happens if the ADA does apply to you, because there's a different set of questions that you ask under the ADA to determine whether or not someone can have their service animal. But in this situation, where we're dealing with the Federal Fair Housing Act, we've walked through those questions. So the definition of service animal, the requirements of service animals under the ADA are not relevant and do not apply to these other situations. And I think that was the last one for service animals. And I feel like I saw a bunch of questions come up during that.
There are lots of questions. Let me go back. Oops. Go down here.
I see that there was one about the difference between emotional support animals and service animals, if you want to discuss that, Nathaniel.
Sure. So under the Fair Housing Act, there is no distinction. These terms are essentially interchangeable. The service animal, the support animal, emotional support animal, assistance animal, they're all interchangeable terms under the Fair Housing Act because there is no training or certification requirements. You can't train an animal to provide emotional support. It's often the act of having and caring for that animal and the companionship that's providing the emotional support. And those are activities that you can't train an animal for. So those terms are essentially used interchangeably under the Fair Housing Act.
And I think we've had two different questions along the lines of what kind of verification a housing provider can ask for regarding the need for a service animal, about the nexus, and about verification that someone's disability requires a support animal.
Sure. So we would go back to the sort of 3 bullet points back when we first went through reasonable accommodation. So first would be in the situation where someone's disability is obvious and their need for the accommodation is obvious, you can't request any additional documentation. So let's say someone has a visual impairment and has a seeing eye guide dog. Their disability would be apparent and their need for that animal would be apparent. So you could not request any additional information. Now, in the situation where someone's disability is apparent, but their need for the animal isn't apparent, then you could only ask for documentation that would establish that nexus between either the disability that's obvious or another disability and their need for the animal. And then the third situation where their disability is not obvious or otherwise known, and therefore you wouldn't know about their disability-related need, you could only ask for documentation that would establish those 2 things, that I have a disability and that I have a disability-related need for that service support assistance animal. Now, what that documentation looked like can be, like, there's no statutory definition for that. It's something that comes from someone in a position to establish that I have a disability. So it could come from my primary care physician. It could come from my psychiatrist, my peer support group, whatever person that is in a position to establish that I have a disability and articulate that I have a disability-related need for the animal.
Thank you. Yeah, I'll say just that as a matter of practice at legal services, we often advise folks to get a letter from a healthcare provider of some type, whoever that might be. Sometimes it's a therapist, sometimes it's a nurse practitioner who's able to provide that documentation. And Nathaniel, I know you talked to us about this, but we had a question about when a service animal causes problems for other tenants, loud barking, odors, attacking, biting, what the options are at that point, how that falls through fair housing law.
Sure. So that covers a range of behaviors. So when someone submits a reasonable accommodation request for their assistance animal, that does not remove the obligations for them to care for that animal. Just as any other pet owner is responsible for their animal's behaviors, their animal's excrement, that person who made that reasonable accommodation request is responsible for those things. So if that person's failing to properly clean and care and clean up after their animal, then that's something that you would treat just as any other tenant who failed to do those things for that animal. just because this is my disability-related device does not release me from the responsibilities inherent in animal companionship or animal ownership. Now, in the situations where that animal has bitten or terrorized other tenants or property staff, or has damaged the property, then we're going to look at sort of our direct threat individualized assessment. And if we can establish that this animal does pose a direct threat and biting someone does seem to be like evidence of a direct threat, then you could take the appropriate actions to mitigate that direct threat.
Thank you. This is a good one with some questions. So there, someone asked a specific question about AB 468, which is a relatively recent law regarding the paperwork for the sale of emotional support animals specifically. Do you want to comment at all? It just asks for a discussion of that and whether the provision regarding the healthcare provider established at least 30 days prior to the need for the ESA. There are a few questions about the timeline in terms of whether someone has gotten a letter that's a long time ago or within the last 30 days.
So I've heard of this, but again, because I only work with the federal laws, I can't claim to be any expert on this. But under the Federal Fair Housing Act, there isn't the restrictions that may be put in place by that bill. The most recent guidance from HUD does get into the use of online certifications and provides a very rough rubric for how you can evaluate someone's use of online certifications. Because it is important to always keep in mind that there are real and understandable and disability-related reasons why someone may engage with a healthcare provider online. So we can't discount all online medical documentation that is submitted in support of reasonable accommodation request, but there is a level of due diligence that one wants to give when receiving these types of things. You want to look at, does the person making this request have some type of patient-provider relationship that existed outside of going online and filling out a 15-minute or 15-question questionnaire? Sort of trying to establish what are the contours of that patient-provider relationship. Have they met multiple times? Was cameras on, so there's actual person-to-person engagement? Was there discussions of diagnoses and treatments and things, like trying to get a sense of the contours and scope of that relationship or those interactions between the online provider and the patient. But I don't know if you have other thoughts or more knowledge about that assembly bill.
It's pretty new, and so I haven't run into it a ton. What I'm aware is that it governs not actually landlords and tenants, but rather the people selling animals and the healthcare practitioners verifying disabilities. So it doesn't, my understanding is it doesn't really create additional rights or liabilities either for a housing provider or someone seeking to obtain a support animal as an accommodation, but it does put some limits on what the kind of the middlemen, the people providing and training animals and attesting to someone's need for a service animal can and cannot do. There was a lot of good questions. One of them was about the intersections of insurance policies with the fair housing law if an insurance policy does not support, say, a large breed.
So I can see how the risk of loss of an insurance policy could arguably pose an undue financial and administrative burden. However, HUD's policy is when a potential complainant contacts us alleging denial of a reasonable accommodation request for an assistance animal, when the housing provider's defense was risk of loss of insurance, we will still take that complaint for investigation, because that investigation needs to evaluate whether or not that loss of insurance would pose that undue financial and administrative burden. So we will take, by policy, we will take those complaints for investigation.
And let's see. Last couple questions. Tom asked if, since a landlord cannot ask for an additional deposit for a service animal, what are the options if a service animal, say, destroys the carpet or affects the physical structure? And Nathaniel walked us through, just because an animal is a service animal or a support animal, that doesn't excuse them or their owner from the general rules that apply to animals in the house, in the building, such as cleanliness, destruction of property, things like that. So a landlord would have all the same options in terms of giving a notice, providing a 3-day notice, initiating court proceedings if necessary, or trying to resolve the situation with a tenant if there's a problem with property destruction, or like we talked about, for a reasonable modification, if there's a need to put the premises back into the condition they were in when the tenant moved in and it's beyond normal wear and tear, billing that to a tenant or going through small claims court if necessary to provide that, to provide the repairs to the premises. I see that someone mentioned they have specifically a dander-free rental as an accommodation for people who cannot have pet dander. What does that mean in terms of requests for dog or cat? Can I deny any dog cat based upon the dog would interfere with our business model? So I guess the question is of dueling reasonable accommodation requests.
And that's a great question. I unfortunately don't have much of an answer to. That is one that we get. There are properties that have been constructed specifically for individuals with various environmental sensitivities, whether it's chemical-based sensitivities or dander-based sensitivities. And so when those properties receive reasonable accommodation requests, we get both sides of that contacting us. So it does become sort of this delicate dance in evaluating competing reasonable accommodation requests. Now, I think that most likely that if someone submits that request, then it would be a situation that would require an interactive process, because the request for the animal is arguably requesting that you fundamentally alter the services you provide as a housing provider, because that service is providing a dander-free environment due to the presence of other tenants with respiratory related disabilities or whatever it may be. And so my asking you to bring in a dander-filled animal would seem to be a fundamental alteration request. So then we would engage in the interactive process. I don't know a ton about animals, but I feel like, aren't there dander-free dogs or non-allergenic dogs or something like that? Or I think this does also end up being a situation where this is where some people avail themselves of less traditional pets. You know, they have reptiles or whatever it may be. But I do think it would be sort of one of those more interactive type dealings in how you evaluate these competing reasonable accommodation requests.
Thank you. I see that there are 2 more questions on this. We'll answer these 2 that are in the chat now and then move on to make sure we have a little bit of time for the last chunk of our presentation. One person has asked regarding emotional support animals, do we need to assume that federal law supersedes California, the bill AB 468 that we just discussed, for landlords to act legally? So it is correct that in general, if there's a direct conflict between state and federal law generally wins. But my understanding is that AB 468 doesn't directly contradict any provisions of federal fair housing law. It's not demanding different things from housing providers and tenants than the federal fair housing law. It's putting more limits on what people providing animals and people attesting to the need for animals can do. But it doesn't, to my understanding, and again, this is a new law, so thank you for bringing it up. To my understanding, it doesn't put new conditions on what a landlord has to do to be in compliance with state law. So a landlord would not necessarily be in a pinch between complying with the state law and being with the federal law. And then one other question was about, does not putting a leash on a bulldog out and about violate California pet leash law? Do you know, Nathaniel? I do not know.
Well, so again, because presumably this bulldog is some type of assistance animal, that does not mean that the pet's owner is not required to follow whatever other associated rules and responsibilities there are. So if there's a leash law, then they need to abide by that leash law. If the locality has vaccination mandates, then they need to follow those vaccination mandates. They need to, again, I recognize that the dog is to be considered a disability device, but that's for the purposes of requesting and accessing a reasonable accommodation, not for the purposes of avoiding whatever other legal responsibilities and ownership responsibilities there are inherent in the act of having an animal.
Thank you all for the questions and the discussion. We have one last chunk, which is actually going to be zooming out from our focus on fair housing and doing a quick skim of some general landlord-tenant provisions. And then we'll come back for a last round of Q&A altogether. Thank you again for your participation and all of these questions. With that, we can hop to our next slide. So I'm briefly going to be taking off my fair housing co-presenter hat and putting on my general landlord tenant hat to talk through some general provisions. And again, since we're going to be doing this in about 10 minutes, it is not going to be an in-depth or individual discussion of a great deal of California landlord tenant law, but to kind of give a that 40,000 foot view of some of the key provisions and protections operating for landlords and tenants. With that, next slide. So one of the key areas of fair housing that we talked through was applying for rental housing. In general, nothing compels a housing provider to accept one particular tenant. However, a landlord cannot deny a tenant for a discriminatory reason. Housing providers can request credit checks, things like that. Tenants then have a right to see that credit check if it's used as part of their evaluation for a tenancy. And this is also an area where tenants can request reasonable accommodations. For example, if someone cannot see to fill out a written application, they might need assistance doing that, or they might need an accessible version of that. Application screening fees are allowed, but only if they reflect actual costs incurred to, say, run that credit check or something like that. Next slide. As Nathaniel walked us through, it is unlawful to discriminate. That would be to not offer a lease or a tenancy or to advertise that is discriminatorily on the basis of all of the protected classes we talked through, including race, religion, gender, disability, family status, and source of income. In general, at the application stage, a housing provider cannot ask questions about those except source of income, because that is relevant to the application process. The exception being then if someone does, request a reasonable accommodation, the housing provider can get the information about nexus that they need to determine how to provide that accommodation. And that includes housing providers cannot make statements or use advertisements that indicate a preference based on these, like no children or like not suitable for families or no Section 8 would be examples of those discriminatory statements in advertising. There's a notable exception to this. Thank you, Mary. You are reading my mind, except there's one notable exception, which is that if someone has a single family house and they are renting out a single room to a single person, I've heard this called like the old Mrs. McDonald's exception. The concept is like your kid has gone to college and their room is now vacant and you're taking in a tenant, because that's kind of an unusually intimate, like a roommate relationship as distinct from renting out a separate house. Most of these are going to be waived if you are renting out a single room in a single family house to a single person. You might decide, hey, I'm actually much more comfortable sharing my home with someone of my own gender, something like that. And with that, we'll move on. One note on immigration status. California law prohibits a landlord from asking about an applicant's immigration or citizenship status. Housing providers can ask for verifications of identity and financial qualifications, including source of income, but not immigration documentation or citizenship status. Thank you. Can move on. Just basics about starting a tenancy. Generally, a rental agreement has to be in writing if it's over 1 year. It's a good practice no matter what to put it in writing. There are some limits on the amount that can be charged for a security deposit. If it's for an unfinished unit, it cannot be more than 2 months rent. A furnished unit can be up to 3 months rent. And it's always a good practice to do an inventory and walkthrough with a tenant at the beginning of a tenancy to identify any damages, any repair issues. This alleviates a lot of issues with security deposits later if there's a dispute about what condition the washer and dryer was in when someone moved in versus when they moved out. It's recommended to do that walkthrough at the beginning and make sure everyone has a copy.
Great idea.
Okay. And I'm briefly going to talk through a big development in landlord-tenant law a few years ago, which was the effort of a big coalition of tenant and landlord and governmental groups that got together and created a bill called the Tenant Protection Act of 2019, or AB 1482, which put into place kind of 2 general big areas of law in California. One is some limitations on rent increases. The other is limitations on the reasons that tenants can be evicted from their homes. So with that, I'm going to talk through the big questions first of who this act applies to, and then what the protections are. So the protections of this act are going to apply to, it's like all units except, and then some very big exceptions. So it does not apply to most single family homes in California, unless the single family homes are owned by corporations, real estate investment trusts, or LLCs with at least 1 corporate member. That means if you are an individual or with a family member, you own a single family home, you wouldn't fall under this act. It does not apply to owner-occupied duplexes. So that could be like a house with 2 units, or it could be a house with a ADU in the back. It does not apply to deed-restricted affordable housing. That is generally kind of like large government-run complexes. It does not apply to new construction from the last 15 years. And then there are a few specific types of housing, types of hotels, university dorms that are accepted as well. There is, Mary and I discovered researching for this presentation, an open question of law as to whether Section 8 units fall under this law. This is a big open question because there's a question of whether it counts as deed-restricted affordable housing. There are aspects of Section 8 that make it more like that. There are aspects that make it more like a traditional rental agreement. So it might depend a little bit on your specific circumstances. If a housing unit falls into one of the other exceptions, like a single family house or a owner-occupied duplex, then AB 1482 will not apply. If it's an older apartment with a Section 8 lease, then arguably this law might apply. And so there are kind of 2 general sets of protections. One is limits on rent increases. Those apply from the beginning of a tenancy. And then there are limitations on the reasons to evict a tenant, which are called just cause protections. Those kick in after 1 year, or if some tenants have moved in and out after at least 1 tenant has been there 2 years. Next slide. So the general structure of limits on rent increases, there are a couple different ways that rent increases are limited in California. One is during a state of emergency, there's a temporary rent cap that kicks in on all housing, whether or not 1482 is going to apply. So at, say, the beginning of COVID, or when there have been wildfires in our service area, there's temporary a rent cap that kicks in that limits rent increases to no more than 10%. Normally, rent cannot be increased during someone's lease unless it's baked into the lease. And then if a unit falls under AB 1482, those rules we just talked about. So if it is, say, kind of a 3-unit apartment building or a larger apartment building where these protections apply, then there's an annual percentage-based increase, which gets set through a calculation based on the cost of living every year. It'll be between 5 and 10% every year. Right now it's 9%. And there's some requirements on giving notice of a rent increase. A provider has to give at least 30 days notice if it's a rent increase of 10% or less, and 60 days notice if it's more than 10%. Okay, next slide. And then we're going to get into a little bit about what the bases are that a housing provider can end someone's tenancy. So if you are not covered by AB 1482, there is no requirement for any particular reason. There are requirements in terms of the notice you have to give, 30 or 60 days notice, depending on how long the tenant has been there, but not on the reasons. For folks who are covered by the Tenant Protection Act, they can be evicted for what are called at-fault reasons or no-fault reasons. At-fault reasons, just like it sounds, are where a tenant has done something wrong, failed to pay rent, broken the lease in some way, caused a nuisance on the premises, is subletting without permission, is using the premises for any legal purpose, things like that. In those cases, a landlord can give a 3-day notice to cure or quit. That means like shape up, fix this in 3 days, or I will give you a 3-day notice to move out. In a few cases where the problem is really can't be fixed anymore, so that might be like major property damage or crime on the premises, then a landlord can just give a 3-day notice saying, hey, there's no chance to fix this, you have to move out. And next slide. Then there's a different set of rules where a landlord needs the unit back for some other reason. It's not related to the tenant, but it's related to needing the unit for some other purpose. A landlord can give notice if they are going to move in or have a family member move into that unit, if they need to make such major repairs that can't happen with a tenant living there, if they're going out of business, they're no longer going to rent that unit out, if they are demolishing the building, or if they are complying with a government order, that might be, say, like, we need to do like seismic retrofitting. We can't do that with a tenant in the building. In that case, they need to give 60 days notice, and they need to provide relocation equal to 1 month's rent, which a landlord can either pay to a tenant or can waive a month's rent. And next one. And then for those folks who do not fall under AB 1482, no cause is required. A landlord can give reason or just say, hey, no particular reason, you didn't do anything wrong, but I need the property back. If that's the case, the provider needs to give 30 days notice for tenants who've lived at the building less than 1 year, 60 days notice if the tenant has been there more than a year, or 90 days notice to Section 8 tenants, people with a housing choice voucher. And then just like the other reasons we went through, landlords can give 3-day notices for failures to pay the rent, nuisance, subletting, things like that, whether or not they're under the protection of AB 1482. A tenant, on the other hand, can give notice if they're on a lease. Generally, the lease term governs. If you're no longer on a lease, generally 30 days is required. It's the amount of time between rent payments, so usually 30 days. All right, next slide. There are some requirements around security deposits. When a tenant moves out, a provider has 21 days, 3 weeks to either return the deposit to the tenant if there's nothing to be deducted, or to itemize the receipt, deduct what they need, and then return the rest to the tenant. The deposit can only go to 4 specific things, which include unpaid rent, cleaning, repair of damages beyond normal wear and tear. So not things got old and I'm replacing them, but my tenant's dog scratched up the carpet and I need to fix it. And then if the lease allows for it, for the case of like furnished units, the security deposit can go to replacing furniture, keys, things like that. It's the tenant's responsibility to give you a forwarding address and to request a move-out inspection if they want it, but then a provider must provide that inspection if requested. All right, next slide. And we have had a roller coaster of different sets of COVID-19 related protections, which I'm sure folks have experienced over the last 2 years. Where we are at now, as of about 2 weeks ago, is in our what's likely to be the last extension of certain protections for folks who were unable to pay the rent during COVID. Where it stands now, effectively, is for folks who owe rent that accrued between the beginning of the pandemic in March 2020 up through last March 2022. There is a set, there are several overlapping sets of protections, but folks who have pending applications for government assistance, the government has to have a chance to process that before a landlord can obtain an eviction judgment. So landlords can give notices, tracking the amount of rent that is owed, but they cannot get an eviction judgment against a tenant until the government has had a chance to finish processing those applications. This protection is in place until the end of June. And that does not apply to rent starting this month, April 2022 and forward. That is due as usual, and there are no particular protections or delays in terms of processing those cases. I'm sure many folks have spent time in the last couple of years with Housing is Key, which is the state rental assistance program. They stopped accepting applications on March 31st and are now in the next couple of months working through that backlog. Those cases where folks are waiting on applications are on hold. They can't move forward through the eviction process until the Housing is Key has processed those through the end of June. All right, so I realized that was a very fast 10-minute overview of California landlord tenant law and not in a great deal of depth. But with that, let's move on to the next slide and wrap up with our last questions here.
There are several questions there, Ari.
Okay.
There was one about asking for a social security card if they need the number to run a credit report.
Oh, that's a very good question. In my experience, Nathaniel, chime in if you know anything about this, but my memory is that tenants are not required to provide social security numbers, partly because a tenant could be qualified and not have a social security card number, but are required to provide verification of identity, which can include other types of documents like pay stubs, government issues IDs, things like that.
From a fair housing perspective, I think through it in two ways. One would be ensuring that if you're doing that, you're doing it to everyone. For instance, not only requiring social security cards from a specific protected class group of people, but also thinking about it, as Ari mentioned, there are other ways of verifying identity and ability to pay that aren't social security number. So if you think about some foreign nationals, for instance, there might be other things that people can provide. So there is the potential that requiring the social security card for verification purposes could have that disparate impact on other protected classes. So just sort of keep that in mind.
Okay, and I see there's a question about selling the property. I assume the question was about whether that's a reason, a just cause for termination of tenancy. All by itself, it is not. If property is covered by the protections of AB 1482 and the landlord is selling the property, that's not a cause to evict the tenant, because of course the property can be sold with a tenant in it and a new landlord can purchase the right to receive those rent payments. However, if the new landlord, say, wants to move in, a landlord moving in is a valid reason to terminate tenancy. So they would purchase that building with the rights as a new landlord to give a notice if they are going to move in themselves. Okay, I see some of these questions are long, so I'm going to take a minute to read them. If anyone is ahead of me, go ahead and chime in.
There's one talking about the COVID non-rent payment is the most abused. But there was an opportunity through California Key for landlords to apply as well. Can you talk about that, Ari?
Yes, absolutely. So that is correct that landlords and tenants both had the opportunity to apply for back rent through Housing is Key. Housing is Key is funded by the state and has been working through back applications. It has taken a very long time to get some of those applications processed. And I see someone saying here that in one case, Housing is Key sent the resident the check instead of the landlord, but the landlord never received it. That could have happened if the landlord did not participate in the program, like did not provide their half of the application process. If that's the case, the Housing is Key would have paid the tenant and not the landlord. But then the landlord would, of course, be entitled to the back rent owing. So I guess the advice to that landlord would be to work it out with the tenant to the degree possible. If not, since there's no pending application, they wouldn't be barred from going through court processes. If a tenant states they are applying. Yeah, so the current regime of rental protections is for folks who have pending applications with Housing is Key. And so if you don't have a pending application, either because you didn't get one in before the end of March, or it was denied, or it was paid out but never made its way to the landlord, then that protection would not apply. It's specifically for pending ERAP applications. There is a question about April rent. It is correct that April rent was due as normal at the beginning of the month or whatever, under whatever agreements are in a tenant's lease, and that a landlord can move forward with giving a 3-day notice in court proceedings if necessary to collect April rent. I see a question about evaluating rental applications on unpaid rent. I'm sorry, I don't think could I ask JP to ask the question? I want to make sure I'm able to provide some helpful information. Oh, is it about providing referrals?
Jean, can you respond on that, on your question? Clarify your question, please. You can unmute yourself.
Thank you.
Can you hear me?
Yes.
So I was in a class and the California Apartment Association was saying we're not allowed to consider unpaid rents for the COVID period, which they seem to say was March of 2020 through March 31st of 2022. So if we get an applicant and they flat out tell us, I didn't pay any rent and I'm just moving because I don't want my landlord to evict me. I'm just wondering how we can legally handle that, because just accepting someone that has blatantly chosen not to be a good partner is a challenge for a landlord. And then if somebody was to send me a referral and I have a tenant who hasn't paid rent for 18 months and who makes a good income, and eventually, hopefully, Housing is Key will process their application, but they may deny it because they have a very substantial income. I'll be left holding the bag for all that rent. And I believe legally I can go and evict them for all that rent past due at that point. I'm just trying to get clarification. So I don't want to give a landlord information about a tenant who didn't pay rent because they're trying to, quite frankly, run because they didn't want to pay. But on the other hand, as a landlord, I don't want anybody to do that to me. So I'm just trying to find out what's legal.
Great question. And I will say right now, it's an extremely complicated landscape about which chunks of time can be applied for which purposes. So I won't be able to answer it in quite as much detail as it would be most helpful. But that said, owing back rent is not a protected class. As we evaluate this case, there might be relationships between that. However, someone might be behind in rent because of disability related reasons. Someone who say got COVID and couldn't work for months and months. The reasons they have that rental debt might be disability related or any number of other things. Maybe they were high risk and couldn't work, things like that. In those cases, then you would apply this analysis of fair housing that we've talked about in order to give folks with disabilities, folks in protected classes, a fair chance at a unit as a non-disabled individual. Those folks might request accommodations, like I request that you not consider, say, my rental debt related to my disability as part of my application, or I request that a prior eviction be disregarded. Here's other things I can use to provide examples of my creditworthiness. Does that provide any help?
I guess I'm confused because
Okay.
I'm pretty sure SB 91 says, as landlords, we cannot consider unpaid rent during the COVID period when assessing a future applicant. So like you guys, I'm just confounded trying to figure out what path is the most legal to maneuver. I certainly want to be legal, but I also want to be a good partner, not only with good applicants and good landlords. So.
Okay, I don't know off the top of my head an answer to that question about consideration of pending rent. And so I'm sorry, I can't provide that one on the fly, but thanks for bringing it up.
Thank you.
I do see a question also about whether a tenant can specify what a specific rent payment is supposed to go for. And that is permitted. Tenants in general, COVID aside, are allowed to designate, this is my April rent payment, this is my May rent payment. Usually the best way to do that is to like notate it on a check or in a portal. And specifically for COVID, even if there is, say, a rental agreement to the contrary, landlords are prohibited from applying payments retroactively. If someone has COVID rental debt from before March, but now makes a timely April rental payment, a landlord is required to apply that to the April rent and not retroactive. Okay, I think I made my way through the questions in the chat. Please chime in if I missed anyone, or if anyone else would like to hop on the line verbally. And thank you for your patience as we make our way through this very complicated thicket of law.
So there was one question, I'm not sure we addressed it. It says, what happens if a tenant states they applied for the rental assistance program and were denied? Can they then serve a 3-day notice?
Yes, so that's a case where there's no longer a pending application. If the landlord and tenant applied, it was denied, there's no longer a pending application, so the pause would not apply to that case.
Thank you for clarifying.
Anyone else I missed? Sorry if I skimmed past anyone.
I think we have all the questions and answers, and we are right about there on our time. I appreciate all the time of Nathaniel and Ari in bringing the presentation to us. I think most of the questions were answered. It's a great presentation in a short period of time. It's different to do it online like we have today, but us as the housing office, we appreciate everybody that was able to attend today, coming and getting their fair share. I don't believe I have anything else, but thank you for everybody that has come in today, listened in on the examples. I think that is it. Thank you again very much, Ari, Nathaniel, for being here today.
Thank you for everyone. Hopefully I'll see you all next year.
In person.
Thank you.
In person.
In person, that's what we're going for. Oh, wait, there's 2 more messages. Let me check. Oh, okay.
And a big thank you to Mary for organizing this. Thanks for all your work and for bringing us together today.
Thank you. I will, anybody that asks about certificates, if you need a certificate, I put my email in here and I can get a certificate for your attendance. Email. All right. I think that is it for everyone. Thank you very much. Zoom, no travel. No. Yes. No participants. Stop screen share.